Good morning and welcome to my seminar at the end of March. My seminar today is entitled Workplace 2021, Trends, Challenges and Opportunities. So what I am proposing to talk about this morning is to make some general comments about Australia's workplace as we enter 2021, some long-term and some short-term trends in particular in response to the pandemic, and also current issues facing employers, including the recent passing of what's been dubbed the Omnibus Fair Work reforms. In terms of Australia's workforce in 2021, Australia currently has a population of some 25 million, and that's predicted to be 35 million by 2050. Of that, Australia's workforce is about 13 million. It's an employment to population ratio of about 62%, though it's expected to go lower in the future. Australia currently has about 800,000 job seekers. That's an unemployment rate of about 5.8%. As we all know, a JobKeeper scheme has been in place until recently. In December of last year, it's estimated that 1.5 million workers were having their wages subsidised by the scheme, and that these were predominantly in Victoria, hardest hit by the pandemic. The JobKeeper scheme, of course, has now concluded. A likely consequence of this is an increase in the number of job seekers. Some have estimated that that will lead to an increase of a further 150,000 job seekers. Further, it seems likely that there will be an increase in the number of those in the workforce who are seeking more hours of work from their employer. In terms of the Australian workforce and long-term trends, a clear long-term trend, in my view, is the move towards a more direct relationship between employers and their workforce. This more direct approach is evidenced from union diversity figures in Australia. In the 1970s, union density was as high as 50%. In 1992, that figure had dropped to 40%. Today, a total of 1.5 million people, or about 14.3% of Australia's workforce, are members of a trade union. Education, public administration and healthcare are the most unionised sectors of the workforce. 780,000, or less than 1 in 10 workers in the private sector, are a member of a trade union. 5% of workers aged between 15 and 19 are members of a trade union, which indicates a clear future trend. Trade unions still play a key role in our industrial relations system, including a key role in bargaining for an enterprise agreement. In my view, in response, employers have left the industrial relations system such that some commentators have suggested, for instance, that enterprise bargaining agreements are going the way of the dodo. Employers are instead negotiating modern working arrangements that are flexible and productive and provide incentives for their employees directly with their workforces. The effect of disruptions caused by the gig economy and the global pandemic have only accentuated this long-term trend. Turning now to my next slide, which is entitled Compliance to COVID. And I've called it this because I can recall last year, early in the year, a real focus from employers in relation to the issue of compliance. This came off the back of some media interest in relation to what was dubbed wage theft, but also the recent changes in relation to annualised salary provisions, which had caused a real focus in relation to the issue of compliance. That was earlier in the year, and then of course the pandemic hit in March, and the focus quickly changed to protecting one's business. The JobKeeper scheme commenced in March last year. That was, as has been discussed, a wage subsidy scheme for those employers impacted by the pandemic. At $90 billion, this is the single largest economic support program from an Australian government. JobKeeper assisted nearly 1 million businesses and more than 3.5 million employees. JobKeeper, as we know, was originally expected to operate for a period of 6 months until the end of September last year. In mid-July, the federal government announced that it would be extending JobKeeper for a further 6-month period, and this was dubbed JobKeeper 2. The JobKeeper 2 scheme has now recently concluded. The JobKeeper scheme, as we know, was supplemented by amendments to introduce temporary measures to the Fair Work Act to assist those JobKeeper employers. A JobKeeper employer under these temporary measures had greater flexibility to make changes to several key terms and conditions of employment for employees in their business. All current workplace arrangements that might prevent introduction of these greater flexibilities were overridden by the JobKeeper laws under the Fair Work Act. The JobKeeper amendments to the Fair Work Act have, like the JobKeeper scheme, now concluded. There's only limited transitional arrangements in relation to issues such as service that remain in relation to those JobKeeper amendments. In terms of modern award reforms, in addition to changes that were made to the Fair Work Act, there were also changes that were made by the Fair Work Commission to the modern award system at the commencement of the pandemic. These were the original pandemic or COVID flexibilities. The Fair Work Commission introduced these originally to the Clerks Private Sector Modern Award. These introduced flexibilities in relation to 4 key areas: an ability to reduce hours of work for permanent employees, an ability to facilitate working from home arrangements, and also an ability to introduce more flexible leave arrangements. The flexibilities which became Schedule I to the Clerks Modern Award were originally to operate until the 30th of June 2020, consistent with the JobKeeper scheme. In addition to that, other awards were also changed, picking up on the same approach that was taken in relation to the Clerks Award. Some of these provisions remain in place until the 30th of June 2021. In relation to the reduction in hours, those arrangements must have been entered into before 30 June 2020 for them to continue until that time. Other changes were also made. The Commission introduced unpaid pandemic leave. This was introduced as a schedule to a number of awards, including the manufacturing, meat industry and wine industry awards. In effect, that enabled an employee to access this additional form of leave if they needed to during the course of the pandemic. This was originally due to cease on the 29th of March 2021, however, has recently been extended until the 31st of December 2021. In addition to that, the Commission introduced paid pandemic leave for aged care workers. This was designed to assist workers in this particular industry. However, that looks set to cease at the end of this month. Turning now to some of the current issues, the Fair Work Amendment Supporting Australia's Jobs and Economics Recovery Bill 2021, which of course is dubbed the Omnibus Bill, has recently passed federal parliament. The bill was originally designed to make amendments to the Fair Work Act to achieve some key reforms. These reforms included in the area of modern awards to introduce greater flexibilities through simplified additional hours agreements and flexible work directions. Secondly, changes to enterprise agreements, most notably changes to the Better Off Overall test. Thirdly, in the area of compliance, the introduction of wage theft provisions, which will be discussed in more detail in my seminar in a moment. And finally, in the area of employment, the introduction for the first time to a definition of casual and also other casual provisions, including those designed to prevent double dipping. In the end, as we know, it was only the casual provisions that were passed by Federal Parliament. The casual provisions introduced in the Fair Work Act have 5 key elements: a new definition of casual, a set-off provision, casual conversion provisions, a dispute provision, and an information statement requirement. I'll deal with each of these important changes now. A new definition of casual employment. The Fair Work Act did not contain a definition of casual. So when the issue of who is a casual came up, the Federal Court dealt with that issue and applied the common law test. And it did so recently in some decisions involving WorkPac, which was a labour hire provider. That led the federal government to introduce a regulation in an attempt to set off in situations where a casual who was paid a loading would then seek permanent employee entitlements. That regulation was not successful in the second WorkPac decision, which has led to the introduction of these provisions into the bill. So a person under the new definition will be a casual employee if an offer of employment is made to the person on the basis that the employer makes no firm advance commitment to continue to an agreed pattern of work for the person, and the person accepts the offer on that basis, and the person is an employee as a result of that acceptance. The definition especially provides that the only considerations in determining whether no firm advance commitment to continuing indefinite work according to an agreed pattern of work for the person is made are whether the employer can elect to offer work and whether the person can elect to accept or reject that work, whether the person will work as required according to the needs of the employer, whether the employment is described as casual employment, and whether the person will be entitled to a casual loading or a specific rate of pay for casual employees under the terms of an offer or a fair work instrument, including a modern award. The definition also makes clear that a regular pattern of hours does not of itself indicate a firm advance commitment to continuing indefinite work according to an agreed pattern of work. The question of whether a person is a casual employee is to be assessed on the basis of the offer of employment and the acceptance of that offer, not on the basis of any subsequent conduct of either party. And a person who commences employment as a casual employee remains a casual employee until their employment is converted to full-time or part-time employment, or they accept an alternative offer of employment, other than obviously a casual offer of employment. The definition, it seems to me, is complex. One of the difficulties of it is the number of criteria that it has, and it seems to me these can be very subjective. It fails, in my view, to set an easy definition of who a casual is to be, which contains objective criteria such as how many hours of work that they work during the course of their engagement. And for that reason, it seems to me it's something that will be very much in practice the subject of interpretation as to whether somebody is or is not a casual for the purpose of the definition. Turning now to the issue of the set-off provision, a court may find that an employee has been incorrectly classified as a casual, and this specifically addresses the difficulties that arose in the WorkPac decisions. The court will, in these circumstances, be able to offset any identifiable casual loading paid to the employee against claims for certain entitlements. And those certain entitlements are defined in the bill, and they include entitlements that a permanent employee would normally receive, such as annual leave. They apply where a person is employed by an employer in the circumstances where the employment is described as casual employment, and the employer pays the person an identifiable amount to compensate that person for not having one or more relevant entitlements during the period. And during the employment period, the person was not a casual employee. That is, they were found by the court to be incorrectly classified as a casual, such that they're a permanent employee, and the person makes a claim to be paid an amount for one or more of the relevant entitlements, for example, annual leave, with respect to the employment period. When making any orders in relation to the claim, a court must reduce any amount payable by the employer to the person for the relevant entitlements by an amount equal to the loading amount, in effect setting off the two against each other. Importantly, the new casual provisions also contain casual conversion provisions. Now, many of us would already be familiar with casual conversion provisions. A number of awards already contain casual conversion provisions. The significance of these casual conversion provisions is, of course, is that it will apply generally to the workforce. And in relation to the casual conversion provisions, there are two types. One is the obligation on the employer to offer permanent employment, and the other is the ability for a casual to seek such permanent employment. So in relation to the obligation to offer permanent employment, an employer, except a small business employer, will have an obligation to offer to convert a casual employee to permanent employment, subject to certain criteria. The employee has been employed for at least 12 months, and for at least half of these 12 months has worked a regular pattern of hours on an ongoing basis that without significant adjustment could continue to be worked as a permanent employee. There is a caveat here, that is, the employer does not need to make such an offer where there are reasonable grounds for not making such an offer. Reasonable grounds include where the employee's position will cease to exist in the period of 12 months after the time of deciding not to make the offer, the hours of work which the employee is required to perform will be significantly reduced in that period, or there will be a significant change in either or both of the days on which the employee's hours of work are required to be performed or the times at which those hours are required to be performed, which cannot be accommodated within the days or times the employee is available to work during that period. In effect, that is saying if the person is truly going to be engaged in the future as a casual employee, then it's reasonable not to make the offer for permanent employment. In addition to the obligation on an employer, except for a small business, to make such an offer, there is, as I said, a right for a casual employee to seek to be converted to permanent employment. In response to such a request, an employer can only refuse it on reasonable grounds, which are based on the same reasonable grounds that have just been described in relation to the obligation to make such an offer. These are based on facts that are known at the time, that is, at the time that the request is made by the casual employee. And an employer must respond in writing to such a request, and if it decides to refuse, must consult with the employee before doing so. The provisions, as mentioned, also have a small claims procedure in the event of a dispute in relation to a casual conversion. So either the employer or the employee may refer a matter to the court, which can then hear evidence about it and make a decision about whether there were, for instance, reasonable grounds for an employer to refuse to convert. In addition to that, there's a requirement now for a casual employment information statement. The statement is to be prepared by the Fair Work Ombudsman and must contain information about casual employment and offers and requests for casual conversion, including the following: the meaning of a casual employee, that an employer must offer casual conversion, that an employer can decide not to make an offer for casual conversion if there are reasonable grounds for not doing so, that certain casual employees will also have a residual right to request casual conversion, and that the Commission may deal with disputes about the operation. The Commission will have some 6 months to ensure that any casual provisions contained in modern wards are consistent with these provisions in the Fair Work Act. In terms of steps for employers to take in response to these changes, the first and most fundamental step is to ensure that there is a written contract of employment. It seems to me that's critical. The contract needs to clearly identify that the relationship is that of a casual employment relationship. Secondly, the provision of the casual employment information statement, when this becomes available from the Fair Work Ombudsman, will need to be provided to all new casual employees employed in the business. Thirdly, it will be necessary for employers to review all long-term casuals in the business to consider whether it is necessary to offer them permanent employment. Fourthly, from a transitional perspective, an employer will have a 6-month transition period before being required to consider whether it is necessary to make offers of conversion to permanent employment to existing casual employees in the business. Turning now to some current issues. The first issue I'm going to talk about this morning is the issue of flexibility. A report from the CSIRO from 2016 entitled Tomorrow's Digitally Enabled Workforce notes the move towards working from home. Of course, this trend has only been enhanced by the pandemic. Over 4.3 million of Australia's 13 million workforce were working from home from March last year. Recent ABS data reveals the number of Australians working from home remains almost double the pre-pandemic figure. 42% of those surveyed would like to retain the option of working from home. In a historic move, the Victorian government has made working from home the new default setting for its public sector workforce. Its new flexible work policy, released this week, introduces a default starting position of 3 days a week in the office for full-time office-based public servants. According to a guidance note from the Victorian Secretary's Board, it is then up to employees and managers to discuss and agree to individual working arrangements based on the principle that we start from a position of flexibility. For office-based roles requiring more than 3 days a week on-site, the guidance note says flexibility will be possible through other measures, or, as explained in the guiding principles, all roles can have some type of flexibility, but not all types of flexibility will work for every role. If there's a good reason a role can't have a type of flexibility, managers and employees must look for a type of flexibility that will work. So it's clear from this move, which may be replicated in the private sector, that we are likely to be moving to a working from home model in the future. The other issue that is gaining significant attention at the moment is the issue of harassment. The Federal Sex Discrimination Commissioner's Respect at Work Sexual Harassment National Inquiry Report was released in March 2020. The report concluded that Australia lags behind other countries in preventing and responding to sexual harassment, and that 1 in 3 people experience sexual harassment at work in the past 5 years. A likely outcome of the report is a variety of legislative reforms to the Federal Sex Discrimination Act and other anti-discrimination legislation. Foremost will be the expected creation of a new positive duty on employers to eliminate workplace sexual harassment, mirroring the obligation that currently only exists in Victoria. Employers can expect that the proposed reforms will generate renewed attention and greater expectations on employers to take proactive action to eliminate harassment from their workplace. But putting aside changes to the law, employers should expect even greater scrutiny of their workforce culture by employees, unions and government regulators, and obviously the media. Throughout last year, there were multiple high-profile examples of behaviour by senior business leaders, judges and politicians which attracted ongoing media attention. Labour law firms are also becoming more frequently active in this space. And whilst legal claims can always be settled, reputations can be harder to repair. Because of this, senior managers and boards are ensuring that workplace safety, culture and bullying receive ongoing attention. The other current issue that is of interest to employers at the moment is, of course, vaccination. That is vaccination in relation to responding to COVID-19. Many employers will agree to voluntarily be vaccinated, particularly industries such as aged care, where that's a significant issue. The issue arises, though, where people are not willing to be vaccinated. And in this situation, an employer may consider providing a direction to that employee. To be enforceable, the direction will need to be lawful and reasonable. A variety of factors may impact the lawfulness and reasonableness of a particular direction, including the nature of the work being performed, the nature of the clients and other relevant persons who frequent the workplace, whether the employee can work remotely, and the advice and requirements of government and medical bodies at the time. There was a recent decision which considered this issue in Glover and Ozcare. The Commission in that decision was required to consider a jurisdictional objection as to whether an employee who had been placed on indefinite unpaid leave because of their refusal to be vaccinated against the flu had been terminated from their employment. So it wasn't actually as to the merits of the termination, but on that jurisdictional point. In this case, the employee had a genuinely held belief that they had a severe allergic reaction to a flu vaccination when they were a child, hence the reason for not wishing to be vaccinated on this occasion. Commissioner Hunt, who dealt with the matter, found that Ozcare had terminated Ms Glover's employment as it had refused to roster her despite her being ready, willing and able to perform her duties. So he did find on that jurisdictional point that there was a termination of employment. The employer had refused to provide her with duties because it considered being vaccinated against the flu in the context of the pandemic to be an inherent requirement of her role. And that was the basis upon which they were refusing to provide duties to her at the time. Ozcare had also declined to provide any certainty about the worker's future employment. In the course of their reasonings, Commissioner Hunt made the following observations. In my view, each circumstance of the person's role is important to consider, and the workplace in which they work in determining whether an employer's decision to make a vaccination an inherent requirement of the role is a lawful and reasonable direction. Refusal of such may result in termination of employment, regardless of the employee's reason, whether medical or based on religious grounds or simply the person being a conscientious objector. It may be that a court or tribunal is tasked with determining whether the employer's direction is lawful and reasonable. However, in the court of public opinion, it may not be an unreasonable requirement. It may in fact be an expectation of a large proportion of the community. My view is Commissioner Hunt's pro-vaccination comments represent a likely approach that the Commission will take towards an employer's requirement to vaccinate for COVID-19. The other issue that I wanted to talk about has been a current issue is the issue of compliance. Certainly in my period of practice, the enforcement of workplace laws has become a greater focus. The federal regulator, currently known as the Fair Work Ombudsman, has received a significant increase in funding from the early 2000s. The regulator has substantially increased enforcement of minimum employment standards through civil litigation, including the seeking of civil penalties against employers. The most common target of this litigation has been smaller to medium employers in the following areas: accommodation and food services, administration support services, and retail trade industries. In more recent times, the regulator has also focused on seeking civil penalties against directors of employers, particularly when the employing entity is no longer trading. In the 2018-2019 financial year, amounts recovered as underpayment or non-payment have exceeded $4 million. Civil penalties have been around $1.6 million. And interestingly enough, probably in a change in approach, the level of on-the-spot fines issued by the Fair Work Ombudsman has totaled nearly $500,000. Over time, the regulator has also evolved from being a complaints-based organisation to an organisation which regularly conducts audits and campaigns to ensure compliance with workplace laws. My observation of these campaigns is that in the last 10 years, they have shown high levels of non-compliance with workplace laws, which was an early warning to the wage theft issue that has been raised more recently. Turning now to the wage theft issue, in 2019, the concern about the non-payment of minimum entitlements became a national issue. The high point came about when the punishment for celebrity chef George Calambris's business empire's punishment for underpaying nearly $8 million was revealed by the regulator. An enforceable undertaking in this instance was entered into with his business empire, which included the imposition of a $200,000 fine and his agreement to doing some speaking engagements for the regulator. Clearly, the regulator didn't take those up. Even the federal government was forced to acknowledge and agreed what the public had already determined, that the fine of $200,000 handed to his restaurant empire over the systemic underpayment of its workforce was clearly light. In response, some states, including Victoria, have passed wage theft laws that criminalise non-payment of minimum entitlements. The federal government had also included, as has been discussed, wage theft as an issue in its omnibus bill. The intention was to create a new criminal offence where an employer who dishonestly engages in a deliberate and systematic pattern of underpaying one or more employees faced imprisonment and also being disqualified from managing a business for a period of up to 5 years. In addition, there were to be increases in penalties, and bigger businesses were to be subject to penalty fines based on 2 times the benefit obtained or up to 3 times the serious breaches. Those provisions, of course, were not passed by Parliament. However, may well be introduced by the Parliament in the future. Turning now to the final part of my presentation in relation to employment claim trends. As I've said, in relation to long-term trends, that is directed towards a more direct relationship between employees and their employer. Similarly, in relation to employment claims, the claims tend to be more focused on the individual. Collective claims and also collective action, such as industrial action, is largely a thing of the past. There was a recent threat of industrial action by the ambulance workers here in South Australia, and that was a rare example, in my experience, of possible industrial action, that is collective action being taken against an employer. There are, having said that, several collective claims in the form of underpayment of wages claims that have been brought as class actions, many of these brought by litigation funders and unions. The reality, though, is that an unfair dismissal application, being, of course, a single application or relating to a single employee or former employee remains the employment claim of choice for employees of the private sector. The Fair Work Commission's annual report for 2019-2020 indicates that of some 33,483 applications that are dealt with in the course of that financial year, that almost half were unfair dismissal applications. There were, in the same year, an unusually high number of applications, about 10%, that dealt with applications to vary enterprise agreements as employers sought to introduce more flexible work arrangements in response to the effect on their operations of the global pandemic. Historically, applications such as unfair dismissal applications, general protections applications, the applicant is often represented by the union or more recently by their lawyer. Recent trend in my experience is that a large number of applicants who commence unfair dismissal applications are self-represented. And this has created a number of challenges for employers in terms of responding to those applications, because they're dealing with people who aren't familiar with the processes and do not correctly understand the merits or otherwise of their applications. In response to this trend, the Fair Work Commission has introduced its Workplace Advisory Service, which seeks to connect both employees and employers with lawyers and others who can assist and advise them in relation to this application. But you can see from that move that the Commission indeed is responding to this trend, which is not only a challenge for parties responding to the applications, but also the Commission, who is spending significant time and resources in assisting the applicant to present their case before the Commission. So those are my comments in relation to some current issues, finishing with current employment claim trends, and I'm happy to take questions at this stage of my seminar.